Hey guys, welcome to this video. This is John Watts. I want us to look at a recent case from the Southern District of Florida, and this concerns standing, or the ability to go into court because you have suffered some type of injury. And we're going to see in the context of this FDCPA, Fair Debt Collection Practices Act case, that the judge in Florida says, while something may have been done wrong, although he doesn't really reach that decision, there's not enough here that the doors of the federal courthouse open. And so this goes back to what we've talked about in previous videos. We need to make sure that we can show why we're bringing the lawsuit. And if there's some question about whether there's actually, quote, standing, then bring it in state court because you can avoid a lot of those issues. So let's look at this. It's a pretty simple case. And the judge says this is a single cause of action against Resurgent, which Resurgent is sort of the parent company of LVNV funding. Okay, they're all these related companies, but this particular case, they're suing Resurgent. Well, what does the consumer say? And what we're looking at here is this is an old JCPenney credit card, and it's like 20 years ago she stopped paying on it. And then eventually LVNV claims to have purchased it. They give a limited power of attorney to Resurgent to collect. And she says Resurgent's efforts are illegal. Well, why are they illegal? Because she sought bankruptcy protection in 2019. Now remember, she stopped paying on the credit card in 1998. And Resurgent files a, quote, proof of claim, which is what any creditor does in bankruptcy. It's saying to the bankruptcy court, hey, we're making a claim, and here's what that claim is. And it's for $1,150. And it says principal only. And she says, well, wait a minute. Resurgent, you had to itemize the principal, the interest, the fees, the expenses, and by putting them all together and just saying principal, that was deceptive. And so she says this is a flagrant disregard or violation of this particular section of the FDCPA, 1692E2A, which says a debt collector cannot commit the false representation of the character, amount, or legal status of any debt. If they do, then they violate the FDCPA. And she says this is perjury, and unsophisticated consumers would have to use their resources to fight this. And if they don't challenge it, then the proof of claim is deemed to be allowed. So what's the response? Well, Resurgent really doesn't respond, at least the way the judge tells us here, on the merits of this. In other words, they don't appear to be arguing whether their proof of claim was right or wrong. They say under Federal Rules Civil Procedure 12B1, you lack standing to sue. There's no subject matter jurisdiction. So subject matter jurisdiction is the power of the court over the subject or the lawsuit. Now let's contrast that with personal jurisdiction. That's the power of the court over the person. So, and I've talked about this in other videos, if I get sued in Wyoming, I've never been in Wyoming, I've never done business with Wyoming, well then the Wyoming court would not have personal jurisdiction over me. Okay. So what we're talking about here is subject matter jurisdiction. And why is there not power over this lawsuit? Because Resurgent's saying the consumer lacks standing to sue. So let's see what the judge says. It says, while the FDCPA may entitle a plaintiff to statutory damages, that's up to $1,000, a plaintiff must still establish some injury to satisfy Article 3 standing. Article 3 comes from the Constitution. Resurgent, the debt collector, says that the consumer alleges no facts establishing she experienced any harm or even the risk of harm. And the bankruptcy proceeding was dismissed on procedural grounds. So there was no conjectural or there was no harm, and any harm that the consumer was dreaming up was just conjectural or theoretical at best. In other words, the bankruptcy failed. So there was no money paid, so there was no risk. So, hey, no harm, no foul. So Resurgent never even had a chance to recover the debt owed. And so the court says, well, let's look at this. So here we have standing. And it says in the second sentence, no principle is more fundamental to the judiciary's proper role in our system of government than the constitutional limitation on federal court jurisdiction to actual cases or controversies. So there's three elements to show that you have standing. You have to suffer an injury in fact, and that injury must be fairly traceable to the conduct that the defendant did that you say is wrong. And it has to have the ability to be redressed or fixed by a favorable judicial decision. And I'll just pause here and say this. As I'm recording this on August the 11th, I read an article about in the General Flynn criminal prosecution where the Justice Department is saying they want to dismiss the charges, and the federal judge is sort of holding on to that, saying, well, I don't know if I'm going to let you. And so it gets taken up on what's called a mandamus to the D.C. Court of Appeals. And the three-panel court said, yep, Judge, you got to get rid of this case. And now they're arguing it before all the judges there. And some of the questions raised by the other judges are, well, wait a minute. We don't know how the judge is going to rule. He might rule in your favor. So what are you doing here? In other words, it's not quite time to be here. That's a variation of what we're seeing here. You have to have an injury, it has to be fairly traceable, and it has to be redressed by a favorable decision. So if the plaintiff fails to meet his or her burden, this court lacks the power to create jurisdiction. And so what do? We're arguing here over the first element, the injury in fact. And so you see this language, which is not particularly precise, okay? It's got to be concrete, particularized, actual, or imminent. It can't be just conjecture or hypothetical. And to be concrete, it has to be de facto, meaning it actually exists. And well, what does particularized mean? It means it affects the plaintiff in a personal and individual way. So we're not talking about affecting other people. We're talking about the plaintiff, the one that brought the lawsuit. And the court notes that even when Congress seeks to punish certain behavior by statute, an injury fact must still be shown. So Congress cannot erase Article 3 standing requirements by granting the right to sue to a plaintiff. Okay, so what does all that mean? So we've got kind of the facts, and now we've got the law. How does the court apply this? It says, the consumer fails to carry her burden of establishing standing to sue. So while she claims to suffer an alleged violation of protected interest, and that is to be free of false representation, the judge says, even if that's true, you did not suffer an injury in fact. So there's no concreteness and there's no particularized damage here that would give you standing. So let's see what the judge says. On this concreteness prong, there's no harm, real or immediate, by the apparent misrepresentation that the money you owe is principal only. And the judge says, look, the consumer doesn't say she was defrauded into paying this or that she spent time and money contesting it or preparing to fight it. And she doesn't even say she suffered an abstract or intangible injury. And so, according to the judge, all she has is this mere technical violation, and that's just not enough. So here we have a quote. A plaintiff may not allege a bare procedural violation, divorced from any concrete harm, and satisfy the injury in fact requirement of Article 3. And remember, what we're talking about is Article 3, which is the U.S. Constitution. We're not talking about where I practice, for example, Alabama State Court or other state courts. Now, every state could decide to have the same type of requirement, but if other states do, it's very unusual. I'll just put it to you that way. And obviously, if you're not in Alabama, you got to check your state. So another quote here is that there has to be an actual injury, or you have to be in danger, And it cannot just be conjecture or hypothetical, like, well, it's theoretically possible I could have been hurt. They're saying, no, 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 that's not good enough. And then this issue of it being particularized, not a word we often use, but let's see what the court says about this. Instead of claiming the consumer was at risk, she says unsophisticated consumers, if they were in my position, would have been forced to use their limited resources. So she doesn't say she had to use her resources. She just talks about it could hurt other people. And the judge says, look, we mean it's got to affect you, the plaintiff, the one bringing the lawsuit. And when there are laws that give you rights, the person will have Article 3 standing where it actually impacts you, not other people. And they say, the judge says, look, this is like a recent 11th Circuit case involving the FDCPA. And here the court vacated and remanded 2 cases. In other words, sent them back to the district court judge and said, there's no standing. Well, and we'll go over that case in another video, but we'll just see the summary here. So the plaintiffs in that Midland Credit case sued because they got some supposedly misleading letters, false impression, the debts they had owed were still legally enforceable. And the court, let me get this highlighted here, said there's no injury in fact because they didn't make any payments. They didn't say we wasted time or money in determining whether we need to make payments, so there's no concreteness. And there's no substantially increasing of the risk of harm to the plaintiffs, the ones that brought the lawsuit. And so the plaintiffs instead said, well, it's just potentially harmful to unsophisticated consumers. And they say, well, that's not good enough. And going back to the case, the Hill versus Resurgent, the judge says, you just failed to allege that type of injury. And any risk of harm would nevertheless have been dissipated by the time of filing suit, as the underlying bankruptcy proceeding was dismissed before you filed suit. So let's think this through. She's in bankruptcy court. This supposedly fraudulent, deceptive proof of claim is filed. But then her case gets kicked out of bankruptcy court before anything can happen, before she even files suit. Now, it might have been different if she had filed suit before her bankruptcy case got kicked out. And it certainly could have made a difference if she could have honestly said, hey, this affected me. I spent money, I spent time, I spent effort, I spent energy trying to figure this out, or I was worried about it, or I stressed about it, or I had mental anguish over it, but we just don't see that. And so going back to this Midland Credit Management case and also this Cooper versus the Atlantic Credit and Finance Company, and let's see the summary here. Relying on that Midland Credit case, finding the plaintiff lacked standing, bring an FDCPA for being confused about her statutory rights to dispute the debt, as well as whether she had the full 30 days, because those allegations are insufficient to establish standing. And then here's one, the Daniels case out of Georgia, which is also from July. So July was a busy month. It says, even accepting the allegations defendant misrepresented the service date on the certificate is true when it wasn't such a minor technical infraction of the FDCPA, is simply not sufficient to convey standing because she really didn't suffer any harm. And then the judge says, because the 11th Circuit does not recognize and, quote, anything hurts so long as Congress says it hurts theory of Article 3 injury. Let me tell you what that means. There's an argument, it's a pretty compelling argument, say, well, look, if Congress says this is a problem, and they say this is prohibited, and they say I can sue, and they say I can get statutory damages, that ought to be the end of it. But the 11th Circuit says, no, that's not enough. You can't just do that. You have to have something more than that. And then quoting from this Daniels case, which I think this is not the most accurate statement here, but it says the FDCPA is a shield to protect debtors from unethical and illegal debt collectors, not a sword to be wielded, force defendants to pay plaintiffs who have not suffered. I think that's actually very incorrect, because it's both. It's to protect consumers, but it's also says to consumers, if a debt collector has done something wrong, even if you weren't hurt, you can sue and get statutory damages. So, with all due respect to the judge that wrote that, it is a sword to be wielded. Here's the issue: you just can't wield that sword in federal court. Okay? You have to file these in state court unless you're confident that you can satisfy that injury, that standing. So, can you explain to the judge why this hurt you, how it caused you harm, how it cost you money, time, effort, energy, worry, whatever it might be? And is that enough in the 11th Circuit or whatever circuit you're in? Is that enough in your particular district? So maybe the Northern District of Georgia is a little bit different than the Middle District of Alabama. Maybe they're the same, maybe they're different. You really need to know for you what the situation is. Now, my solution in these is almost always to file these in state court. And then if the other side takes it to federal court and then they raise these issues, I say, yeah, judge, that's fine. You don't have any jurisdiction, so send it back to state court. And that usually shuts down that argument very quickly. So hope that that's helpful to you. I'll put a link in I'll pin a comment with the link to this case is Hill versus Resurgent. There's also some footnotes here that you can read that explain things a little bit more. And I appreciate you watching this. And like I said, this is the Hill versus Resurgent Capital, Southern District, Florida, July 31st, 2020 case. And if you like this type of video, just let me know and I'll do more of these as I run across cases. Okay, have a great day. Bye-bye.